The IStructE knows this is a burning topic for many of its members, and this was clearly evidenced by the very many and very insightful questions that we received in response to this surgery event. Much more clarification and information on the Act remains expected from the Health and Safety Executive, the government, and the Building Safety Regulator, and that includes some secondary legislation which has not yet been released. I say that by way of preempting the fact that today's session, not every question yet has an answer. So what we've decided to do is also have our solicitors, our construction solicitors, to explain more about that legal context. And I welcome Joe Fox and Sadia McAvoy from Ashurst. And so what they're going to do is provide a brief overview of the Building Safety Act and what we know so far before we start into the questions. To introduce the two of them, Joe is a senior associate in the environment and safety team at Ashurst and advises clients in the real estate, energy, waste and infrastructure sectors on a wide range of transactional, advisory and contentious matters. Joe has a particular interest in fire safety at the planning and occupational stages of development, and she's an active member of the UK Health and Safety Lawyers Association. Sadia is Head of Client Solutions for the construction team at Ashurst and an expertise counsel, specialising in non-contentious construction law, acting for developers and contractors in the drafting and negotiation of all forms of construction documentation and advising them on regulatory matters, including building safety. Following the talk by Joe and Sadia, Patrick Hayes will also join them. Patrick is the technical director at the IStructE. Patrick's been an engineer since 1988 and chartered since 1993 and has designed structures in both the UK and overseas with experience covering schools, universities, laboratories, commercial, residential and mixed-use developments. He leads the technical and engineering policy development of the institution, working closely with the institution's members. Patrick leads the institution's Building Safety Act initiative, which involves assessing the needs of members to meet the requirements of the Act and working with other PEIs to produce guidance. He's ideally placed, I'm sure you'll realise, to answer many of the questions that were submitted. The panel tried to cover all of the issues requested in the submissions. For ease of doing so, we've combined some of the submitted questions. So hopefully you'll find your answer here, even if the question's worded slightly differently from the one that you issued. And just to say finally, I think this is still the case, there's a chat function if you want to submit a comment. But due to time constraints, we probably won't get to any new questions on the chat. It's more for discussion purposes or to raise something that maybe you want one of the panel to see. And with that, I will hand over to Joe and Sadia of Ashurst. Thank you very much.
Many thanks, Helen. As Helen mentioned, there are a lot of outstanding and unanswered aspects to the Act, and that's the reason why we're giving this short overview. But I have to start by acknowledging that the Act is very long. It's a horribly complicated piece of legislation, and in due course, it's going to be accompanied by lots of different pieces of secondary legislation, many of which we've seen published in the last few months, but there's also going to be many more. It has to be read in conjunction with legislation like the Defective Premises Act, the Building Act 1984, and of course, building regulations. So it is very complicated. And if it's any reassurance, we are all struggling to keep track. You're not alone in that. What we'll cover in this summary is the impact of the Act and other fire safety related legislation on new projects. As many of you will know, there are lots of bits of the Act that deal with the obligations on owners when a building's occupied in terms of managing that building and its obligations when selling assets. But you'll be relieved to know we're not covering that today. But just firstly, we'll hand over to Joe, who'll briefly cover the planning and fire safety elements, and then I'll pick back up on the construction elements.
Thanks, Sadia. We're beginning with Gateway 1 today. So what Gateway 1 does is it brings consideration of fire safety matters to the planning stage of a development. So this is all part of the post-Grenfell move to ensure that fire safety is considered throughout the life cycle of a building to ensure that we have integrated thinking. So fire safety should no longer be an afterthought, it's not a box ticking exercise. For example, matters such as site layout, safe escape routes, emergency vehicle access should be considered at that planning stage. A key element of Gateway 1 that you may all be aware of now is that developers have to submit a fire statement setting out fire safety considerations that are specific to the development at hand. This applies in England, and these statements need to be submitted with applications for planning permission where the development involves one or more relevant buildings. So I've got up there on the slides. In this context, what is a relevant building? Well, here you're looking at buildings where you've got 2 or more dwellings, so that includes flats or educational accommodation, and a building which is 80 meters or more in height, which is about 7 or more stories. Now, height here is measured from the lowest ground level to the top floor surface of the top floor of the building. So that's ignoring any story which is purely for machinery or plant, and any story which is entirely below ground level. You'll see there are 3 exemptions to needing a fire statement. You've got your minor material amendments, your Section 73 applications, applications for outline planning permission, although note that outline permissions will have a condition that require the submission of a fire statement as part of any reserved matters application, and applications for certain material changes in use. It's worth noting as well that permitted development rights for relevant buildings have been amended such that a fire statement must be submitted as part of the prior approval process. And that we have a slightly different situation in London. So London has its own London Plan fire statement requirement, which is more detailed than the Gateway 1 fire statement. So in practice, you'll find that you need your Gateway 1 fire statement with an additional information. So that could be a supplemental statement or a combined document. I checked yesterday and it looks like we're still awaiting the final version of the London Plan guidance. However, the consultation explains that London Plan fire statements will be required for Section 96A and 72 applications. So that is obviously different to the Gateway 1 situation where you've got your kind of Section 73 exemption. A final version of that guidance is expected later this year, but that's what we're expecting to see. So just briefly a little more detail on those fire statements. So they are not intended to duplicate information that will be provided at the building control application stage. They are in fact designed to support local planning authorities as they consider fire safety issues which are relevant to land use planning matters. So as we said before, things like site layout, access, this is not about building regulations. And on the form, you also have the opportunity to talk about things like consultation with the health and safety executive and to identify any departures from statutory guidance or British standards. Fire statements, the forms tell us, should be completed by a suitably qualified engineer with relevant experience in fire safety, so such as a chartered engineer, or a suitably qualified and competent professional who's able to demonstrate experience to address the complexity of the design that's being proposed in terms of fire safety. And a final note on those fire statements, they should cover the whole red line boundary, so not necessarily be limited to the building. We're obviously interested in things like building to building fire spread as well. Before I hand back over to Sadia, I just wanted to cover kind of 3 key fire safety developments. So the first, we've got the Fire Safety Act. So that was introduced in April 2021. The main part of the Fire Safety Act covers an important clarification to the fire safety order on external walls and structures. You might have heard quite a bit about this and that kind of term clarified, and effectively it's clarifying that for buildings with 2 or more sets of domestic premises of any height, that the fire safety order applies to the structure and external walls. So that includes cladding, balconies, windows, and doors between domestic premises and common parts. So the effect of this clarification is that fire risk assessments for blocks of flats need to be updated, if they have not already, to take into account the structure, external walls, and stores. Second development, just to note, is under Article 50 of the Fire Safety Order, that allowed for guidance to be issued to support responsible persons with discharging their duties. So if you haven't already seen it, we now have the Fire Safety Act Commencement Prioritisation Guidance. So that is one that's worth taking a look at. And then finally, the fire safety regulations came into force in January this year. The main purpose of these regulations is to impose obligations on the responsible person of existing residential buildings, and they cover the majority of the Grenfell Inquiry Phase 1 report recommendations. So as you can see, appreciate it's whistle stop, and we're just trying to, as Helen said, give you a bit of a flavour here of those kind of fire safety developments. And Sadia is now going to try and do similar on the Building Safety Act.
Thanks, Jo. So this slide has a lot of material on it, but it's important stuff. And what it tells us is the recent changes in the secondary legislation that's been published to support the Act. The top one's still only in draft, but the final version is expected shortly. And this is the Responsible Actors Scheme, which will stop developers who haven't signed DLUHC's pledge contract. In other words, they haven't committed to remediating and paying for life-critical fire safety defects from working in England. So essentially, planning rules and building control requirements will act as barriers to stop those developers from operating in England. The second SI is in force, and this fulfills the provisions of the Act, which provides that the building safety regulator has replaced building control authorities for higher risk buildings. Third and fourth relate to the obligation for owners to register their existing buildings. And the last two relate to defining what constitutes a higher risk building and the initiation of the BSA. So my point in respect of this slide is just to emphasize that things are changing really fast. On the next slide, you'll see a link to the extensive guidance notes that DLUHC has published. They are helpful, but again, they're over 400 pages long, so unwieldy and difficult, but probably the best place for your first port of call if you're looking to clarify an aspect of the Act. Now, while we've seen a lot of these SIs coming through, what we haven't seen are the SIs with the details of what the new regime will look like for the design and construction phase. And that's despite the fact that the government had said that this element of the Act would be enforced by October of this year when they released their timetable back in 2021. These statutory instruments were promised by DLUHC this spring, but they haven't appeared yet, and DLUHC haven't given any indication as to when they will come. But what we do have is the Act, obviously, and some draft material that was published on DLUHC's website in 2021, but they then withdrew, as well as the contents of a consultation that some of you might have heard of. And that consultation was about the duty holder regime and the government's proposals. So it's with that information that construction lawyers have been anticipating what will be coming down the line. So what do we know? On this next slide, I've set out the 3 ways that the construction phase is going to change. Some of these changes apply to all buildings and some only to higher risk buildings. But the whole purpose of all of them is essentially to impose new and more onerous obligations on those involved in construction to comply with building regulations and to ensure that buildings are safe. One of the overriding purposes of the regime is to make sure that there are responsible persons for structural and fire safety throughout the life of the building. And that responsible and accountable person is called a duty holder at the planning and construction phase, and an accountable person once the building is occupied. And this reflects the essence of the whole purpose of the Act and the way in which the problems of Grenfell, in other words, the lack of accountability, have been addressed. And I think it's really helpful to keep this in mind, that the focus on all of this change is less on what constitutes a safe building and more on ensuring that responsibility for safety is addressed. And the way that the government anticipates that responsibility will be addressed is to create a regime that's modelled on the CDM regulations. As many of you know, the CDM regulations govern health and safety of the construction site during the course of the project. The new regulations will govern the safety of the building. So what do we think these duty holders are going to have to do? In essence, they're going to have to take responsibility for ensuring that building safety is considered throughout the project and that building regulations are complied with. Of course, we already know that building work has to comply with building regulations. The difference will be that if a building doesn't comply, there will now be clear responsibility for that failure. Like CDM, the client is bound by statute to appoint competent duty holders. And as with CDM, there'll be a principal contractor and a principal designer with responsible for safety. One helpful development, and I put a link to it on the previous slide, is that the BSI and DLUC published PAS documents that some of you might have seen at the end of July last year. They're on the BSI website, and they set out competency standards that have been approved by DLUC for the PC and the PD role. These documents don't deal with CDM at all. They're just for ensuring compliance with building regulations, and they're the best indicator we have of what duty holders will need to do. So as I said, it's up to the developer client to ensure that the duty holders have those competencies, and the client will have to provide prescribed documents with their building control applications to demonstrate competency. And the government also proposes that they'll have to sign a declaration that they've assessed and are content with the competency of the principal designer and principal contractor. It's not clear what the transition arrangements will be, but on high-rise residential projects, a developer won't be able to start construction without having these duty holders in place. And this brings me on to the gateways, which you'll have read about. The duty holder roles apply to most building works, unless it's very small, but for higher risk buildings, that's where the gateway regime comes in. And again, we haven't seen the secondary legislation that's actually going to bring this change into force. But once it is in force, developers won't be able to start building on a higher risk building until the client has demonstrated to the building safety regulator that these duty holders have been appointed and that they're competent. This is called Gateway 2, and as well as checking those competencies, the building safety regulator has to be satisfied that the building design meets the functional requirements of the regulations and that the golden thread obligations will be met. What the BSR is going to be looking at is to see that the client can demonstrate that in relation to fire and structural safety, design decisions are well considered and justified to ensure that they'll work effectively when the building is occupied. In terms of timeframes, the government has said that it will take 12 weeks or longer to determine an application. Gateway 3 is when construction work is completed, and it should be noted that there's various stages in between that the building safety regulator can inspect and require their own approval. But Gateway 3 at the end is when completion work is construction work is completed, and then the project is assessed again to make sure it's compliant and ready for occupation. So at PC, the client would apply for a completion certificate. DLUC refer to Gateway 3 as a hard stop, so you can't register, or a developer won't be able to register their building for occupation without getting this certificate. But this certificate again involves another assessment process that again might take 12 weeks. The registration for occupation process is distinct from that completion process, and both must be completed before the building's occupied. The rationale is that no building or part of a building is occupied before it's safe, and that building owners have all the information they need to manage safety during occupation. At this point, all the golden thread documents and information are handed over to the new building owner. And a final point to note before turning to the golden thread is the building safety levy, which the government's introducing to recoup the cost of remediating cladding in orphan buildings. So that's one where there isn't a developer, who's committed to pay for the remedial works. Again, we haven't seen the secondary legislation, but the government's current thinking appears to be that 60% of the levy will be paid at Gateway 2, 40% at Gateway 3, and it will be payable by developers of all residential buildings, regardless of their height. And then I'm sure you'll all be aware of the golden thread, which stems from Judith Hackett's findings that there was a lack of complete, accurate and up-to-date information to pass on to owners. And it will be up to the duty holders to ensure they participate in ensuring that that information is provided. There's some guidance on the website, the government's website, and I've put a link in the slides to know how to prepare for this. But again, the precise requirements will be set out in secondary legislation. So they're the three key elements of change. Lots of lawyers are nevertheless thinking, even though they're not enacted yet, about what they can do to future-proof construction contracts. The most common amendment we're seeing relates to extended limitation periods, and we've got a couple of questions on those that we'll pick up later. Other changes I'm seeing are contracts anticipating the golden thread requirements and using those government's published guidance to establish what information should be collected and stored and how it should be stored. A lot of our clients are unsurprisingly concerned about many of the practical issues, such as responsibility for producing the documents at Gateway 2 and 3, liability for delays in passing through those gateways, particularly concerns about the resources of the building safety regulator, the impact on when PC is certified, in terms of things like safety and security of the site, who insures the site, should things like performance bonds remain in place for longer, what about retention release? So as with other aspects of the Act, I can only conclude our summary by saying that it's a moving feast, but everybody in the construction sector is experiencing the same difficulties, and we can only proceed sort of incrementally. And now I'll pass back to Helen so we can move on to the questions.
Thank you so much, Jo and Sadia. That was a really useful introduction to what we do know, and I think more tellingly what we don't know at the moment about the BSA. I see Patrick's turned his camera on to join for the question session, so I shall dive right in with question number 1, which is, I think, probably best for you, Patrick. It is my understanding that the new regulations will apply to all work to which the Building Regulations 2010 apply, not just high-risk projects. Am I correct in that the new roles, such as the BSA Principal Designer, will therefore be required to be appointed on even the most low-risk of schemes?
Yes, that's correct, Helen. The new duty holder regime applies to all building regulation work in England and Wales. So even on domestic projects, a principal designer and principal contractor must be appointed. And importantly, where the client doesn't appoint a principal designer or a principal contractor, then the lead designer and the lead contractor will assume those roles.
Brilliant. Thanks, Patrick. I think the next question is on more about roles and duties. So Sadia, I think it might be one for you. Could you please clarify the role of the principal designer under the BSA, which I believe is different to that under the CDM regulations? And you touched on that in your presentation, I think.
Yeah, thanks, Helen. That's correct. As I said earlier, the principal designer under the Building Safety Act is responsible for ensuring compliance with building regulations. That contrasts with the CDM regulations, where the duty holders are concerned with the health and safety matters relating to the project. But there are overlaps and similarities, particularly that both sets of duty holders have a lot of obligations in terms of cooperating with other duty holders, coordinating their work, communicating and providing information. These duties will apply to all designers, and then the principal designer, like with CDM, sits above them, controls the process and has additional coordination and liaising duties. The best place to look for more information on what will be expected of a principal designer are those PAS standards that I referred to, and the consultation that DLUC ran last year, which is on their website.
Brilliant, thank you. And those links will be on your slides, which will circulate, is that right?
Yeah,
so
that's correct.
Excellent, thanks, Sadia. Another one on roles and duties, and I think one for you, Patrick. What are the roles and responsibilities of the design team members when things are not defined in the contract? Among the design team members, I'm including their author, lead engineer, engineering manager, project manager, engineers, peers, document controller, and the client's team with mirrored structure.
Well, under the duty holder regime, the principal designer and principal contractor will always be in place, and designers. And anyone carrying out design, building regulation design will be a duty holder. So it doesn't matter if these are defined in contract, they're defined by statute. Also, our understanding is that this is going to be a transition regime, so that any building which has been commenced in October will carry on with the existing regime, but other buildings, transitional arrangements will apply. So designers and contractors could find themselves in the duty holder regime for an existing building. So even on an existing building, if it's not designed in contract, as I said, the lead designer would become the principal designer, the lead contractor would become the principal contractor. Anyone carrying out design on a HRB, or sorry, on building regulation work would be a designer, and anyone carrying out construction work would be a contractor, and they must ensure compliance of their work with building regulations and cooperate with others and be competent as well.
Understood. Thanks, Patrick. The next question is quite a specific one, or the example given is quite specific. And again, I think it's probably for you, Patrick, to answer. In the foreword of CIOB REBA, a guide to managing safety critical elements in building construction, it states that all those involved have a duty to ensure a safe and compliant installation. Could you please explain, Patrick, where this duty comes in, especially, for example, a masonry pier supporting a beam?
Well, we are looking to adopt the recommendations of that report in our own guidance on gateways and what should go into a construction plan. But it's important to understand that that is not a statutory document in itself. The requirement on designers is that the design should be building regulation compliant, and that it also should be implementable, i.e. it can be built. It will remain the duty of the principal contractor to ensure that the construction itself is compliant. So in terms of the example that's been given, a masonry pier supporting the beam, it would be important to ensure that you can actually get the beam onto the pier. Obviously that the pier and the mace and the beam meet building regulations themselves, but it can be built. So in that domestic example, it's not always possible to get the beam onto the pier because the beam's too long. In this instance, you would need to ensure that you can actually build that. So similar to building to TDM, that you can build it safely, the requirement is that you can build to building regs.
Excellent. Thanks, Patrick. The next question, I think, is a really interesting one, one that people even outside of building control be interested in. And again, Patrick, I'm afraid third in a row, I think it's for you. But as a checking engineer for building control, that's the person posing the question, what are my extra responsibilities under the Building Safety Act?
Well, under the Act, the Building Safety Regulator will be the building control body, will take over building control for England and Wales, and they will be the building control body for all high-risk buildings. So other building control bodies will not be able to carry out that function on HRBs going forward. Now, for individuals within the building control profession and for building control companies, the Health and Safety Executive has issued a building inspector competence framework and operational standards rules, and they can be found on the HSE website, and they've literally just been issued. And they set out the new rules for the profession, both in what they should do and their competence requirements. One very important aspect of that is that inspectors now are not allowed to give design advice. There's that separation between sort of design and regulation. So where in the past on small projects, building control inspectors may have advised foundation things. They're not allowed to do that anymore. So the best thing to do is go to the HSE website and look at what they've published for the building control profession.
Excellent, thank you. Now we're turning to more liability and legal-based questions. So Joe, I think this one's for you. If I'm a duty holder under the BSA, can I be personally criminally liable if I fail in my duties? And if so, what are the potential penalties?
Thanks, Helen. Yeah, a big question here. Existing duty holders under CDM, so your clients, designers, principal designers, contractors, principal contractors, they're going to have new duties under the revised building safety regime. The HSE categorises those as duty holders planning, managing and monitoring their activities in relation to building regulations. And that is where obviously this question of personal liability comes in. So we're awaiting secondary legislation, as you've alluded to, and Sadia mentioned, and we're awaiting that for the details. But we expect that the duty holder regime will be similar to CDM, including having that potential for personal criminal liability. So what we do know so far, for all offences in the Building Acts, that's 1984, and Part 2 and 4 of the BSA, and notably Part 4 relates to higher risk buildings, where an offence is committed by a corporate body with the consent or connivance of a director or other similar officer of that corporate body, or if it's attributable to their neglect, that person will be liable to be prosecuted as well as the corporate body. We also know that the building safety regulator will be able to issue two types of notices. So we've got compliance notices, so they require issues of non-compliance to be rectified by a certain date. And during that design and construction phase, you get stop notices, so they require work to be halted until a serious non-compliance is addressed. And failure to comply with those notices will be a criminal offence. And there you've got a maximum penalty of up to 2 years in prison and an unlimited fine. And in the event of a prosecution, it's important to remember that a typical PI policy is likely to respond in a very limited way. For example, it's unlikely to cover fines or the cost of correcting breaches. So yes, to the potential for personal liability, definitely one to watch.
Thanks, Joe. It's a really interesting point about PI coverage as well. So the next question relates to very specifically to the golden thread. So Patrick, I'll throw this one to you. Who will be responsible for storing project documents for the required 30 years? Is it the building owner, the contractor, or the consultant, or presumably all three, perhaps?
Well, there are actually two questions in there. With a building in occupation, the principal accountable person is usually the building owner or the person who's got responsibility for the common areas will be responsible for storing the golden thread. But that's for the life of the building, so that's more than 30 years, and they can delegate that to someone. Individual duty holders now, as Joanna and Sadia mentioned, now have increased liability, and that period's been increased for 30 years. So they will need, duty holders will need to keep their own information for that period of 30 years, and we're recommending they do along with evidence that they've actually complied with building regulations. So two separate things. Golden thread, which will be the responsibility of the principal accountable person, and then evidence of compliance, which will be the duty holder, and that'll be for 30 years.
Brilliant. Thanks, Patrick. And when you say that we're recommending, is that information on the IStructE website? That kind of information? It
will be. We're producing guidance at the moment on gateways and safety cases and golden thread, and that will include recommendations for what information is stored and how that's stored. We do need to wait for the secondary legislation to come out before we can publish that guidance there.
Sure, thank you. Yeah, as everyone's noted, a bit of a movable feast. So the next couple of questions relate to liability and liability periods. So Sadia, I think these are probably best for you. The first of these is, as the extension to liability periods is statutory, is it right to assume there is no need to extend the liability period within our appointments?
Yeah, thank you, Helen. That's a really good question, and one that we are experiencing a lot at the moment. So it is correct that the extension to liability periods under the Defective Premises Act and the Building Act are statutory, not contractual. But what we are increasingly seeing in the market is developers looking to extend their contractual recourse against consultants and contractors to match that statutory liability that they will have under the legislation. So as you'll know, many of you, currently construction contracts and appointments typically include a 12-year limitation period running either from completion of the services or from practical completion of the project. But the extended limitation periods under the Defective Premises Act and the Building Act are for 15 years going forward. So it's quite helpful if I give you a practical example. So if we take a homeowner who brings a successful claim against a developer under the Defective Premises Act on the basis that their home is unsafe, and they bring that 14 years after the work's completed, the developer is going to be liable because of the 15-year liability period to pay damages to the homeowner. The developer may want to recover some of those damages from members of the professional team who advised on the design for that project. Under contract, the developer would be out of time because of our typical 12-year limitation period. It would, however, have rights to bring a claim under statute, under the Contribution Act 1978, against the consultants, but its ability to recover its losses would not be assured in the same way as if the contract was the basis of the claim. And that the reason for that is because if a court is assessing liability under the Contribution Act, it does so on the basis of what it considers is just and equitable, whereas under contract, the doctrine of joint and several liability applies. And it's because of this uncertainty in terms of recovery that we are seeing the market moving towards extending contractual limitation periods to reflect the increased statutory liability under the Defective Premises Act and Section 38 of the Building Act. And consequently, the obligation to maintain PI is also being extended to cover that. I hope that wasn't too legal.
Interesting. No, really interesting. Thank you, Sadia. So I guess a follow-on question, you might have partly covered it, but does the extended liability period apply to all buildings going forward?
Yeah, in respect of claims under the Defective Premises Act, the extended liability period only applies to dwellings, so it's not all buildings. But under the Building Act, the extended limitation period will apply to all buildings. And it's probably helpful here if I explain what a Building Act claim actually is. So Section 38 of the Building Act 1984 says that there's a statutory cause of action for damage suffered as a result of a breach of the building regulations. Now, you might think, well, why are we talking about something from the Building Act 1984? Because that was a long time ago. Well, that provision, that section has been on the statute books since 1984. But it was never enacted, so it never became effective law. But DLUC had said that it was going to be brought into force through the Building Safety Act in June 2022, but that didn't happen, and they haven't explained why they didn't bring it into force. But if and when it is brought into force, developers are going to be looking for that protection, the same as I outlined to respond to the previous question. So going forward, you can expect to see developer clients asking consultants for longer limitation periods and to maintain professional indemnity insurance for the duration of that longer period. But clients should only be asking for that longer limitation period in relation to these specific statutory provisions and not a general extension across the board.
Brilliant. Thank you, Sadia. A lot to think about there, I think, to unpick legally. So the next question, we had a few on this, relates to competency, which obviously is a big part of the BSA. So I'll turn to you, Patrick, for this one. Is there clarity from the government on how civil or structural consultants can demonstrate competence for their role?
Yeah, there are two separate work streams on that. Within the secondary legislation itself, there is general guidance on competence and how that will be assessed. So the recommendations within the secondary legislation that we've seen are that duty holders, designers should either have the experience or be a member of a professional institution. Also, the process will be that the principal designer will need to assess the competence of designers. At Gateway 2, those competency assessments will be passed to the building safety regulator, who may actually comment and object on that. So there's a two-level process. Now, in terms of the competencies themselves, following Grenfell, the sort of industry got together through the Engineering Council and developed working groups. There was a British standard developed, PAS 8670, which set out competencies for those working on high-risk buildings. Through the Engineering Council, the institution then developed contextualised competencies, and those have been assessed against our core competencies. So we now have an assessment of the technical and behavioural competence requirements. We are producing guidance on that at the moment for APs to use. And it's also intended that there will be a register of engineers which we will run with the ICE for those working on HRBs. Now, that register will obviously take some time to put together to get everyone on it. So in the meantime, we will be giving guidance A to members and B to principal designers on how they can meet the competency requirements for working on HRBs.
Excellent, thanks, Patrick. I'm going to jump in and add my own question there, if you don't mind. Does that mean that so chartered engineers, presumably you're not necessarily a shoe-in because it's related to HRBs, not all building design?
That is correct. There are additional requirements to work on HRBs, and they predominantly relate to two areas. One is around structural fire engineering and also understanding buildings and systems, so we can look at the impact of structural and fire systems and the other way around. And importantly, because the legislation is trying to push through cultural change, behavioural competencies. So again, the institution, along with other PEIs, will be sort of running initiatives, just setting out what's required in terms of safety culture, very much in the way that CDM regs were trying to change the safety culture.
Fantastic, thank you. Sorry to ambush you with my own question. Chair, prerogative of the chair. Thank you very much. Another question, another one for you, Patrick, I think. What advice can we give to clients who own a flat in a building that's over 18 metres? And there are two scenarios here. One, if they're not planning any works, and two, if they're planning works with minor structural alterations.
Okay. Well, under the secondary legislation, building owners will need to register their building before October, develop a safety case and golden thread of information. So the sort of the freeholder of the building or the landlord should be doing that. The secondary legislation that we've seen does cover work to existing high-rise residential buildings. And it categorises the work into major work and notifiable work. So if the client isn't planning any work, really they don't really have to do anything. If they are planning minor structural alterations, then that will need to be assessed by the accountable person within the building. They'll need to notify them, and they will then get categorised into either major works or notifiable works. If they're major works, then the whole sort of gateway regime will come into force. There'll need to be a principal designer, principal contractor. If they are more minor works, then the regulator will need to be notified. But there is not so stringent a regime. So any works that affect fire or structure will have to be notified, and pretty much all works will need to go onto the golden thread, even if they're not structural fire related.
Right, thank you very much. The next question relates to gateways and is quite specific. And Joe, I know this is your area of expertise. There's a lot of confusion around the issue of second staircases. Could you please clarify the current position?
Yes, of course. Well, without us sounding like a broken record, we're in consultation territory again, but I'll kind of give an overview of where we're up to. So the consultation on the single staircase ban closed in mid-March of this year. The government's response is expected no sooner than October. I believe that's the same month that we're expecting to see the revised BS 9991. I haven't heard any noises about when we're expecting to see the revised ADB, but obviously lots of things need to come together to give us more information here. And I appreciate that means that developments are really, they're left in limbo until this future legal position becomes clear. What we do know from the consultation is that the proposed changes will only relate to England. We know there's going to be a very short transition period, and to be honest, quite an unusual one here. So the transition period will allow time for schemes to be completed, but the consultation says that they should not allow the opportunity for developments to get off the ground. That's the wording used in the consultation. So that means that even if a planning permission has been implemented, that might not be enough, for example, if the development has begun with a basement. So it all depends on what that get off the ground means in practice. When it comes to the threshold, so the height thresholds, the government's preference appears to be for this new rule to apply for residential buildings over 30 metres, but consideration was given to a threshold as low as 11 metres, and as I'm sure you'll all be aware, there's a lot of support for an 18-metre threshold. So, you know, we've seen that from the Royal Institute of British Architects and notably the London Fire Brigade. Finally, a kind of point on scope, I suppose the consultation states that existing builders won't be captured. In London, many of you may be aware the requirement already applies for planning applications that are referable to the GLA. That's been the case since Feb this year. The GLA requirement is currently set at 30 metres, but obviously that may change if we end up with an 18-metre ban. Developers have largely been public about the impact. It's something that we're certainly hearing about in our day-to-day work. I know Berkeley have publicly said that they will focus on low-rise development if there's a single staircase ban. Ballymore, I think even a year or so before this consultation came out, were making noises, you know, about the fire brigade kind of raising concerns about single staircases. I think that was a 50-51 story residential block in Canary Wharf, which they took back to planning. More recently, I think Landsec have done the same. They've revised the plans for their 1800 home development in North London. I saw that in the news just this week, I think. So we are seeing a lot of developments having to go back to planning, and it's a bit of a watch this space in the meantime.
Thank you, Jo. Moving back again to competency and a bit more specific on the competency requirements, Patrick, how do we ensure the structural engineers have the knowledge in advising fire risks relevant to structural design at each REBA stage as required in the BSA?
Well, we're currently preparing guidance on the gateway submissions and golden thread, and that will overlay on the REBA stages. So we're actually talking about gateways 1, 2, and 3. Joanna set out earlier the requirements at gateway 1 for ensuring fire access, and at gateway 2 we will be setting out or advising structural design predominantly around progressive collapse in fire for the advice that members should be giving, and then gateway 3 is ensuring compliance with that. It's important to note that the structural engineer's duty will relate to the structure, so the fire engineer will still sort of comment on fire risks, but there is an interaction between fire and structure, which the regulations intend to review. So we are currently developing a fire engineering course for members, which we expect to be out sort of Q4 this year or Q1 next year. In the meantime, we would refer members to our Introduction to Fire Safety Engineering of Structures, IStructE 2020, which really gives a good grounding on structure-fire interaction. And we will also be covering this in our forthcoming safety case guidance, which again, both the golden thread and safety case guidance will be coming out post the secondary legislation. But in the meantime, I refer to our introduction to fire safety engineering.
Excellent, thank you, Patrick. I think the next few are all for you. Again, quite a specific example. If working on a residential single dwelling and the client is insistent that they do not wish to appoint an architect and engineer beyond tender for cost reasons, how should we advise the client? And the follow-on question is, what duties do architects, engineers have in informing clients of duties beyond tender? For example, specification of contractor, QA during construction, and so on.
Okay, well, under the Act, designers, similar to CDM, have a duty to advise clients of their duties, and they can be found on the HSE website. So that would be the start point. As I said earlier, if the client does not specifically appoint a principal designer, then the lead designer will assume that role. Now, for our members, that's really important, because there isn't an architect involved and the work is predominantly structural, then the structural engineer could end up being the principal designer. And then post construction, if the architect and engineer aren't appointed, then the contractor will pick up the principal designer role and obviously be responsible for the design. And our members, I think, should make that clear to the contractor that they're picking up that role. There will still be a duty on the client to ensure that, you know, they are appointing competent people. So my advice in that instance would be advise the client on their role under the Building Safety Act, and that, you know, they will have to employ competent people, and by default they will have a principal designer and principal contractor anyway, and ensure that the contractor is aware of their design duties and the fact that they will pick up the PD and designer duties if the design team aren't novated. Now, in terms of QA, there are two things. One is that, say, under the Act, the designers are responsible for ensuring the building is implementable to building regulations, but it is the contractor and the principal contractor who are responsible for construction compliance. So really the role is to ensure that the design can be buildable.
Excellent, thank you. And I think the next question is sort of widening a similar theme out. As a sole trader, I work alone, but in discussion with the building owner, client, and the contractor. Are there any special implications for me?
I think the important thing there is to understand that the duty holder requirements still apply to domestic projects. So any building regulation work that is carried out in England and Wales. So you know, the best thing to do is go onto the Health and Safety Executive website, but there is a requirement as the designer to ensure that the client is aware of their duties. And I say, if a principal designer is not appointed, then the designer may pick up those duties by default. So I'd ensure that the client has appointed a principal designer. And if the client doesn't and the member still carries on with that work, that they are aware that they could pick up the principal designer duties, so should therefore be responsible of those duties.
Yeah, thanks.
And sorry, and they still need to be competent for that role as well. So whilst the building regulator will assess competence on HRBs, every duty holder must demonstrate their competence, so should really be aware of what the institution says for the different grades.
Yep, definitely. Thank you. And this one is really interesting, actually, to do with peer review. So self-study research into BSA information indicates that peer review of all calculations, drawings, reports, and so on may become a necessity. Are there any indications or guidance on how sole traders are to operate in the future, especially for those of the incorporated structural engineer grade, like the questioner? I think there's probably two separate questions there about peer reviews and about incorporated structural engineer grades.
Yeah, I think there are two things there. The Act itself just requires that design should be compliant, and importantly, as Sadia picked up earlier, should be compliant with the functional requirements of the building regulations. So this isn't just compliance with approved documents, but the the use of those approved documents is appropriate. Now, there isn't a default requirement to have that information peer-reviewed and checked. However, under the building regulation, the new regime, the principal designer will pick up responsibility for ensuring that all the design is compliant with building regs. So we can foresee principal designers actually asking designers that they do get their work checked. And I think that's more likely what's going to happen, and that designers may well need to give a compliance statement to designers. So, pardon me, and the regulator themselves, as part of their regime, they may insist for Gateway 2 that designers have their work checked. And that's very similar to what happens in the rail industry. You know, they actually enforce categories of checking. So that's the advice I would give. You know, that there isn't a statutory requirement at the moment, but you may well need to get things peer reviewed. Now, in terms of how that's carried out, we have a small consultants panel, and it may be, you know, that people want to get together to cross-check work. The second question, in terms of how we'd advise incorporate structural engineers, again, there are two things there. One is for work on non-HRBs, and the second is work on HRBs. Now, everyone needs to be competent for what they're doing, so I'd go back to what we have in our core competence requirements and roles to make sure that people are working within their competence. But for those working on HRBs, there will need to be a designer who will effectively take responsibility for work. So again, we will be producing guidance for those on HRBs on how they can meet those designer requirements.
Excellent. Thanks, Patrick. That's the end of all the specifically directed questions, I think, but there's one which is a really interesting one, and I think one that we're all interested in the answers to from everybody on the panel, which is, from your position, how do you feel, either positive or negative, about the challenges facing the industry in terms of the Building Safety Act, and how is it responding? I might go to you first, Sadia, for your view on that one, and then maybe a discussion between the three of you for, I don't know, because we started late, how many minutes we have left, but maybe we just keep talking until someone tells us to stop. I imagine there's a lot to say.
Thank you, Helen. Well, I think generally we're all in agreement that the duty holder regime and the concept of the golden thread are good. But I think there are a lot of short to medium term challenges. I think the jury's still out on whether the building safety regulator will be able to meet the demands that are anticipated. I think we need to know more about how the insurance market's going to respond to the additional duties. And I think in the short term, you know, that especially as we've seen on this call, the way that the changes are coming so unpredictably and so incrementally causes a lot of stress and a lot of challenge and a lot of uncertainty, and that's really difficult in the current climate where we already have a lot of difficulties in the sector, you know, with inflation and supply chain issues and meeting sustainability targets. So yeah, challenging, but some of the principles of the legislation, I think, are sound.
I would second that. I think, you know, one of the main challenges that we've seen today is lack of information. You know, we were waiting a large body of secondary legislation and guidance with an increasingly short period of time to get to grips with the detail before those changes are brought into force. Yeah, I do feel positive that clients are, you know, taking steps to understand the information that we do have, making changes across their business. You know, we've got great attendance today. Again, more people just trying to work out what it is that we do know, what steps they need to take now. For developments that are stalled by the single staircase ban that came up in the questions earlier, you know, the best we might get before the autumn is guidance from the National Fire Chiefs Council that they've talked about putting something out to kind of try and help fill this void. But that, of course, will be superseded by the government's position. So we could have a situation where the guidance advocates an 18-metre threshold, which could result in development, unnecessarily going back to planning if we end up with a 30-metre threshold. Or the opposite could be true. We could have developments that kind of steam ahead expecting 30 metres and find that they have to kind of pull things back to be able to comply with an 18-metre standard. We're also waiting more information on evacuation lifts. They might be captured by the revised BS 999-1, the revised ADB, but we're not quite sure yet. So I think it's easy to feel negative about the delays around second staircases, but everyone in the industry is in the same position. Sadia, mentioned, I think, insurers earlier, investors, insurers, they are going to be more cautious. We understand investors and rating agencies, they're currently expecting double staircases at 18 metres, and until they get a clear kind of 30-metre sign from the government, that's what they're going to be expecting. I suppose just to jump in, if we've got a few minutes, kind of it's a challenge that we are seeing on a kind of it's not quite day to day, but one that is coming up quite often, is the disconnect between fire and rescue authorities' role as a statutory consultee, so during the kind of the construction development phase, and as an enforcing authority under the fire safety order. So in theory, if the fire and rescue authority, the FRA, expresses no concerns at that building control stage, they shouldn't change their view. And of course, then, we shouldn't be seeing any alteration notices, for example, once the property is occupied. That's unless new information comes to light or there's a material change in circumstances, like a ban on single staircases. I think if there is a positive to take away here, I believe the London Fire Brigade in particular, they're undergoing quite a large recruitment exercise at the moment. So hopefully what we're going to see is, more timely information being obtained during that development stage to hopefully kind of help with that disconnect. Although a practical step that I think we can all be taking in the meantime is making sure that when information goes across to the FRA for consultation, it's complete, and that where possible you include contact details, so that should they have the resource, the FRA are able to get in touch and get any more information they might need, even kind of what stage is this development at, okay, you've got a single staircase, but what other measures are in place. Yeah. Just a few thoughts there.
No, it's really interesting. Thanks, Jo. Patrick, I'm told that we've got about 2 minutes. So I'm sorry to squeeze you, but in less than 2 minutes, would you like to sum up your views on, and maybe those of how the institution's feeling about things at the moment?
Yeah, we are positive about the basis of the legislation. As Dame Julie said, this is a sort of a once in a generation opportunity to transform the industry and deal with the issues that arose out of the Grenfell tragedy. So we're fully behind the legislation and the movement behind it. There is also sort of a real focus. We have the industry safety steering group. So this isn't just a piece of legislation. This is being backed up. The health and safety executive are doing lots of work as well. I think that the government have made clear that this is now down to industry to run with, which is sort of maybe slightly different, that we can't look to government. So I think those that adopt the Building Safety Act and the culture change, I think will see the benefits of it. Those that do not, I think, will be challenged because they will be forced into adopting it. That said, I think there are challenges during the transition period. It's a completely new building control regime, and again, those resources need to be built as well. So overall, very positive about the culture change and the impact, but there are challenges during the transition period over the next few years in getting it through.
Certainly, thanks, Patrick. And I think the IStructE has published an awful lot of guidance, even with the lack of secondary legislation being issued, and is doing a lot to support its members, including this surgery, which I hope everyone agrees has been really interesting, really informative. Sorry if we haven't answered your specific question that you sent in, or a question that you now have. The aim is to answer all of the submitted questions eventually, and they that will be probably after the issue of the secondary legislation, because as has become evident, there's a lot of things that can't yet be answered. And so that's the primary reason, if we haven't answered a question, that it's not answered here. And that information will all be on the IStructE website. There'll also be a link to Ashurst's slides from their presentation, which had some useful links in, I'm sure everyone will find really helpful as well. And there's already a lot of information, as I've said, on the IStructE website, and signposts to where to get further information.